You are entering an area where photography, audio, and video recording may occur. By participating in this webinar, you consent to such recording media and its release, publication, exhibition, or reproduction. Good evening, and thank you for joining the Atlanta Suburban Alumni Chapter and the Economic Development Committee for tonight's exciting and informative program. The next person you will hear from is our chapter president, Sabrina Clark, followed by me, Sandra Jeffrey, with an introduction of tonight's speaker, attorney Valencia Aileen. Please submit your questions in the chat as tonight's webinar will be followed by a Q&A facilitated by Tiffany Hutchinson. Thank you and enjoy.
Good evening. I am Sabrina Clark, the chapter president for the Atlanta Suburban Alumni Chapter. Welcome to our Code Red webinar series. Tonight, we would like to help you secure your legacy. We are thrilled to have you here this evening. What makes tonight especially special is March is not only Women's History Month, but it's also Asset Management Awareness Month. This event is all about estate planning, wills, trust, and retirement accounts. Whether you are at ground zero with estate planning or just want to learn from others, we hope you leave feeling informed and supported. You are in for a treat with our very own chapter member, Sarah Valencia Aileen. Enjoy tonight's event.
Valencia is the founder of the Aileen Firm LLC, specializing in estate planning, with a strong commitment to helping her clients create, protect, and transfer their wealth. She understands the importance of having a well-crafted estate plan to ensure that assets are distributed efficiently and with minimal tax implications. In addition to her law practice, Valencia co-founded the ABLE Group, a nonprofit organization focused on financial literacy. She is dedicated to educating the community about financial empowerment and regularly speaks on topics related to wealth preservation. A published author, her work has earned her recognition as a Georgia Rising Star by Super Lawyers and as a legal elite by Georgia Trend magazine, along with awards from the Georgia Association for Women Lawyers and Professional Organizations. Outside of her professional endeavors, Valencia is an avid sports fan, singer, and pianist.
Thank you, Sandra. Good evening, everyone. So we have a lot to cover this evening, so I'm going to get right into it. Our goal for this evening is what kind of documents are included in your estate plan. We're going to talk about how all the documents work together and what's the importance and why do estate planning to begin with. So 4 out of 10 of us, and I say us, I mean Americans, have no plan whatsoever. 40% of the other 60% have an outdated or inadequate plan. And what that really means is for 64% of us in our families, we're not protected adequately. And so my objective and goal this evening is to help you get out of the 64 and get your plan together today. So with that being said, what is the risk of your family if you don't have a plan? So there's no confusion. A lot of people, even though you're doing your estate plan, it's really not about you because you'll be in heaven and we want you to be in heaven. It's about the legacy you leave behind and how they manage your affairs, unfortunately, when you pass away. The real question is, will it be expensive? Because we're going to talk about probate, time consuming, and will it be emotionally draining? I talk with clients all the time, and I look at death as a celebration of life. And what I mean by that is when our loved ones leave this earth, we should be celebrating their memory, not the stress of, well, where did they leave their documents? Who do I need to call? So my role in helping families is to ease that burden, because it is a tough subject to talk about for a lot of people, but take the myth away. You get it done. You may have some updates, a few during your lifetime, but it really is to take that stress and that burden off of your shoulders so you can really just focus on what's important, which is remembering your loved one. And then are you and your financial wishes, because what we talked about a moment ago is unfortunately when you transition. But what happens while you're still here? We want to make sure, so we look at estate planning holistically. Not only are we planning for when you depart this earth, but we want to make sure if for some reason you could not speak for yourself, are your health and financial wishes known to your loved ones? So with that said, let's dig right into it. So what does a complete estate plan look like? You have what we call the healthcare directive here, advanced healthcare directive here in Georgia. You have a HIPAA authorization, a durable power of attorney. If you have children, which we'll definitely want to talk about, is nominating a guardian for those minors. God forbid you pass away while they're still not of legal capacity. And do you have a will or a trust? One myth I want to debunk out the gate is estate planning is not a one-stop shop or one size fits all. We all have different assets. We are at different phases of our life. And so when you're working with an attorney, it's important that we're listening to what your needs are, because what they are today may be very different than what they are 10, 15 years from now. So your estate plan should not be, okay, I got it done, let me put it in the closet or in the drawer and never look at it again, because I can guarantee something is most likely outdated. One of the funniest, I shouldn't say funny, but it happens. Maybe we were all in love and we got married and that marriage didn't work out. But you got you had your children or whatever, and you did your estate plan when you're young, don't think about it. And then you get a divorce, never think about going to update your estate plan. So that person that you wanted to get away from as far as you could ends up or could have the potential of inheriting your estate because you put that in the drawer thinking that you were done. So one of the things I definitely always start out with clients is choose a date that you can remember. It could be your birthday, could be an anniversary, could be a holiday, but you should look at your estate plan on an annual basis. It doesn't mean you're going to change it, but our objective is always to be proactive versus reactive. So what you were doing or what you owned 20 years ago, you may not even have children then. We are making sure to the best of our ability that your estate plan is as current as it can be until you depart this earth. So when we talk about the Advanced Healthcare Directive, well, what is it? It actually, in Georgia, combines the features of, you'll oftentimes hear people say, I have a living will and I have a durable healthcare power of attorney, because every state has different rules. But in Georgia, we combined it into one document, and it is called an Advanced Healthcare Directive. And it names who your healthcare agent should be. In other words, who should be speaking on your behalf if you ever become incapacitated or deemed incompetent, maybe you develop Alzheimer's or what have you, and who should be who do you trust to make healthcare decisions? I oftentimes get, well, I don't need it, I'm married. Okay, well, you could be, but your spouse can't make a decision if their life depended on it. Or you have very strong conditions. And so maybe you don't believe in blood transfusions. Maybe you're Jehovah's Witness, but your spouse or your best friend or whoever you've listed as your agent believes just the opposite. When you're thinking about, well, who should be my agent, you want to list someone that even if it goes above their belief system, that they truly would honor your wishes. That's number one. Number two is that when you have had that Advanced Healthcare Directive, you always keep your original. You should never give your originals to your doctor or anyone. they should make a copy and put it on file. So that way, in case the emergency comes and you're unable to speak for yourself, your wishes are known and they're with your PCP, or whoever your healthcare provider is. So when you're thinking about it, it very well could be your spouse. It may not be. I'm not here to tell you one way or the other. What I am saying is make sure you're thinking about that, and don't think about it lightly, because if you're adamant about no resuscitation, or you want to die a natural death and you don't want feeding tubes, those should be in writing, because again, as I said before, this part is about you, and we respect and honor your wishes even if you can't speak for yourself. The important thing about healthcare directive, what it is not a HIPAA authorization. There's a distinctive difference. So the Advanced Healthcare Directive gives your agent the authority or the consent to handle your medical decisions when you can't. A HIPAA authorization, on the other hand, allows your care provider to release your medical information to your agent or whoever you wanted to receive that. It doesn't always have to be a healthcare agent. It could be your children, and they're not listed as your POAs. So it's very important. The healthcare providers are under strict federal law to respect your privacy. So when you are drafting a healthcare power of attorney, or as I said, we call it an advanced healthcare directive here in Georgia, make sure that if you want your medical information to be released, that HIPAA authorization is included and drafted with your healthcare power of attorney, or again, what we call the advanced healthcare directive. Now, that is about healthcare. There's two power of attorneys. You've got your advanced healthcare directive, and the second one is what you see here, your durable power of attorney. They both are enacted in the similar manner. Whenever you are incapacitated or deemed incompetent, this is when your durable power of attorney would kick in, when you couldn't voice for yourself and you need someone to step in for you. The difference, however, is that the durable power of attorney is all about financial information, someone to pay your mortgage, renew your life insurance policies, pay taxes. So again, this could be, if you're married, most likely it's your spouse, but maybe it isn't. Maybe your brother is a CPA or a financial advisor, and you feel like he's in the better position to manage your financial decisions if you couldn't. Again, this is no judgment. I call it the judgment-free zone. The most important thing to take away is just making sure that when you're thinking about an agent who, one, is going to respect your wishes, two, who is going to act in a fiduciary and responsible manner, because we hope that the power of attorney is just temporary, right? Maybe you have a temporary ailment, maybe you don't, but if you are able to then return to speak for yourself, you can rest confidently that those wishes were carried out as though you were doing them yourselves, right? And this is, again, a fiduciary. So I mentioned that no one can just act willy-nilly or free with your funds. So when we say the word fiduciary, there can be civil or criminal penalties if someone is mismanaging your assets. So again, it should be someone that you trust, someone who has the capability and the understanding of how finances work. And also, sometimes, especially when we get older, maybe our loved ones, our siblings, our parents, our spouses, they may have predeceased us. And so maybe you don't have someone that in your circle any longer that you trust could manage those affairs. One thing you can consider is you may want a corporate or a bank to step in and act as your POA if you don't have someone that's close to you. But the most important, hopefully this has resonated already, is just making sure you have someone or an entity in place that's going to act as your POA. So we talked about so far while you're living, which is your healthcare directive, your HIPAA authorization, and your durable power of attorney. But the question and what completes an estate plan is a will or a trust. And when you have a trust, we have a portable will, and nominating a guardian if, again, you have minors. So let's take a deeper dive. What does that really mean? When we talk about estate planning, what is in the estate? What does it include? A lot of people will come to me and think it's only their home. The home is one of a list, as you can see on the screen, of your assets. And the most important thing that I like to tell, to use this as a practical example, if I go into the bank and my name is not on that account, the bank is not going to release your information to Attorney Eileen because I'm not on the account. I can't tell you how many people will do an estate plan and don't think about their financial assets. And so when we get into the subject of why a trust versus a will, this is going to make more sense. But it should be any asset that is titled in your name or you're the account owner of that you should be considering planning for. That is what we mean by having a full-blown thorough estate plan, where we're looking across the board at all of your assets and how you want to leave them for your loved ones and how do we protect them. So how will your assets be distributed? Will you, in other words, how will your wishes be fulfilled when you leave this earth? The two main options that you often hear about is a will or a trust. And here's where the fun begins. Well, which one should you choose? Because if you remember, I said there is no one size that fits all, or there shouldn't be. So we'll start with the simpler one, which is your last will and testament, or your living, your will. A common description that you hear about a will is it's a letter to the probate judge. So if you don't remember anything I say this evening, even if you have a will, or if you don't, you're going to go to probate court. And why is that important? If your objective is to avoid probate, then you do not want to do a will. But before we get there, let's talk about when you do have a will, because you may not own any property, right? You may only have bank accounts. A trust holds oftentimes the biggest asset being real estate, but it holds other things. But if you don't own any real estate and you have really a simple estate plan and you just want to make sure your wishes are clear and outlined, then you want to have a will. With that being said, if the only asset you have is your bank account, a lot of people again think that then I don't need to go to probate. It's why I use that example on the front end, that in death is treated as though when you're living. So if your name or another person's name is not on that bank account, then you're going to end up going to probate court. In Georgia, the threshold is if your loved one knows that you have less than 12, they just increased it from 10,000 to 12,000, I believe. If you have less than 12,000 in your accounts, you can do what's called a small estate affidavit, where you don't have to do full-blown probate to be able to distribute those proceeds to your loved ones. But in your will, you could say, I leave everything to my 2 children equally. So how we avoid probate, because again, if all your other asset is just a car and your what we call tangible personal property, your clothes, your shoes, your furniture, again, there's no reason to spend the money and the time to go to probate for a small estate like that. But you want to make sure that if there's any dispute, this is why you do write a will. You want to make sure your wishes are clear. And so because if it is what we call a contested estate, then it is clear to the probate court what your wishes were and who you wanted your assets distributed to when you passed away. But assuming there's no friction, there's no conflict, and using the example I said before, where you just had your bank account and a car and your personal belongings. Well, one of the things you should do is make sure you have what we call a POD, a pay on death beneficiary with your bank account. It basically turns your bank accounts into what we would consider like a life insurance policy or 401k, where you have a beneficiary designated. So that way, upon your death, it is not considered part of your estate. You can distribute that asset outright to whoever you've listed as the beneficiary. So if you have a bank account and you've never heard the term POD, or again, the term pay on death beneficiary, I want you to call your bank. And I want you to say, I need to put a beneficiary or beneficiaries on my bank accounts. That way, it serves two purposes. One, I can avoid probate because whoever I've listed as a beneficiary will get those proceeds, however percentage you've allocated for them. But two, and most importantly, because my name of the game is I don't want creditors to get anything if I can help it. Because it can be an outright immediate distribution to whoever you've listed as your beneficiary, then that means even if you left this earth with $100,000 of student loans, it does not matter, because with that beneficiary designation, the proceeds never entered my estate, and whatever I've left in that bank account goes straight to my beneficiaries, thereby avoiding creditors' claims. Why is that significant? So I'm going to pause here for a second because I get this all the time. Just because someone sends you a bill in the mail after your loved one has passed does not mean you pay it. There is a procedural, and we call it creditors' claims here in Georgia, that in order for them to be paid, we have to substantiate, is this debt valid? So they need to file a creditors' claim with the probate court. And if there are no assets to distribute, then those creditors just don't get paid. Part two of that is, well, I know mom or dad would want me to pay. Well, maybe they did, but you are never liable. I repeat, you are never liable for anyone else's debt. So if mom and dad left you all the money in their bank accounts, left you as the beneficiaries of the life insurance policy, left you as the beneficiary on their 401k, all of that is considered non-probatable assets, and they will go directly to whoever you've listed. And whether or not you left this earth with debt, your creditors can't get their hands on those proceeds for whoever you left behind. If for some reason you did not do those things that we just highlighted above, then like I said before, your estate is going to end up going to probate. Here are the top 3 reasons, specifically if you own real estate, why I'm not a fan of probate. 1, it's costly, which we'll get to in a second. 2, the average estate is averaging about a year plus to open and close the estate. That means you can't close the chapter and let your loved ones rest because you're dealing with the probate courts, right? To try to administer their estate. And then third, a lot of people don't realize an executor under Georgia statute, an administrator can receive compensation 2.5% of the value of the assets coming into the probate estate and 2.5% of the value of the assets being distributed. So when you add in the fact that creditors take priority or precedent over beneficiaries, and an administrator, especially if your loved one died without a will, can legally basically get 5% of the estate without even pulling out your calculator, you can see just how much, before we even get into other things, what you just let basically swift away and pass away before, instead of going to your beneficiaries, which I'm sure is your goal. So that is the basics. If you have a simple estate, writing a will, even if it doesn't get probated, is still important because we want to, in case it's ever contested, then the court knows what your wishes were, and they would have to be honored. Secondly, and most importantly, if you have minor children, and let's say there isn't another parent, you know who you want raising your children. You want to ensure that a guardian that you trust has been listed in your will to take care of your children if for some reason you could not and they were still minors when you passed away. Now, the fun part, the trust, and why I'm such a big fan of it. So everything that I just talked about goes out the window when you have a trust, if it's properly funded. The key word is if it is funded. And you guys are probably asking, well, what does that mean, Attorney Alene? It does not mean go out and get a bank account. Literally what it means is whatever assets will go back to now you own a home. And you want that property to go directly to your children. Before you passed away, retitled that asset and took it out of your personal name and into your trust. And when you do that, assuming, let's say that was the only asset of your estate, now I have bypassed probate court because I as an individual passed away, but that asset before I left this earth was owned by my trust, and trusts do not go through probate, and therefore it can be distributed outright to your beneficiaries. That's the first benefit. But before you even get to passing away, let's say you own your primary residence and you own 3 rental properties. You're a sitting duck because those assets are all in your personal name. So let's say someone slips and falls on one of the properties. Now your whole portfolio is exposed because as an attorney, when I go to do an asset or a skip trace, to determine if this is worth my time, I'm going to see the person I'm suing, do they have anything I can actually get my hands on to pay for whatever judgment I may win? So it's an asset protection tool as well while you are living, because you were injured and you're suing me as an individual. But again, I don't own any assets because I made sure I did some asset protection planning and I moved my assets into the trust so that my personal name, when you do a skip trace on Valentia Alene, you're going to find absolutely nothing. So it's not only saves the time, the cost, the headache, creditors coming after the estate when you pass away. It's a great tool to protect you when you're living. A second example of how a trust can be powerful, in Georgia, we have what's called a 5-year look back rule. And that means, because I get this all the time, maybe mom has shown some signs of dementia and now you want to hurry up and add your name to the title. Well, I hope mom or you or someone has some money because you're trying to make sure the nursing home can't get their hands on, your mom's home that she wanted to leave for you. The problem is the average nursing home right now costs about $7,000 to $9,000 a month. So if you don't have long-term care insurance, they're already going to immediately take your Social Security, but there's usually a gap. In that gap, it's bigger and bigger and bigger the longer that your loved one stays in a long-term care facility. And at the end, because they don't collect it while they're living, they come looking for you when that person has left the facility. If you do not have the funds to pay that bill, and there's a worksheet that if you've ever had a loved one who unfortunately has to go into a long-term care facility, there's a worksheet that they have you fill out and it asks you, have you transferred any assets or sold anything in the last 5 years? They're asking that question because they can go back and unwind that transaction to satisfy the debt that you owe to that facility. So I'm not here to be Debbie Downer or Debbie Gloomer. The most important thing is just for you all to see how important it is to plan early, to plan while you have your faculties together, because then one thing that can happen, the older we get, and unfortunately it happens a lot, if someone calls me and they've been recently diagnosed with Alzheimer's or dementia, it's not worth me losing my license because most likely it's going to get contested anyway with a loved one who feels like they were slighted, and they're going to question that person's ability and capacity to have entered into that contract, if you will, to change their estate. So and my hands are tied. If you have any diminished capacity, I cannot do your estate plan. What you're looking at that point is either looking at conservatorship or guardianship of your loved one, and you have to make a case to the court that they're no longer able to handle their own affairs. But that does not help you when the loved one has passed away. That only allows you to manage their affairs while they're living. So hopefully what's resonating is you can see the difference between a will and a trust, but the benefits, especially if you own real estate, if you have significant funds in your bank accounts, you want to protect those assets, and one of the best ways to do so is with a trust. You'll oftentimes hear about revocable and living trust. Revocable allows you to be the controller of that asset, meaning I can revoke the trust tomorrow, I can add things in the trust, I can pull things out. What happens is upon your death, it becomes irrevocable, meaning whatever you've outlined in that trust, it cannot be changed. The job at that point of what we call your successor trustee is simply to administer your assets, or your estate, and distribute your assets per the wishes that you've designated and written in your trust. The other is an irrevocable trust. Those are not as common. There's two scenarios where I would recommend it. If you have a significant amount of wealth, and right now, a lot of things that us estate planning lawyers went to school for, we don't do as much, because when Congress back in 2011 passed a flat tax, the estate tax for a individual to even have to be concerned about estate tax is 10 million plus inflation, which is right about 12 million right now. If you're a couple, you only have to be concerned about estate tax. The threshold was 20 million, and it's about 22 million with inflation. So if your portfolio is not there now, but maybe in the future, then we're looking at an irrevocable trust, because we're trying to find ways to reduce the tax liability of your estate, because estate tax is one of the largest tax in the Internal Revenue Code. So if you are anywhere close to a net worth of 10 million or 12 million as an individual, or about 22 million above as a couple, then you definitely need to come see me so we can look at ways to reduce that tax base. Because when you have an irrevocable trust, it requires a third-party trustee. You cannot have direct control over that asset, and there's some other rules. The only other reason, and I shouldn't say only, but the other most popular reason is you're doing some Medicaid planning. If you know anything about Medicaid, not everyone qualifies for Medicaid anyway, because you have to have a certain income that's really low to even qualify for Medicaid. But maybe you're retired and you only get a Social Security, you didn't have a retirement account, and so your only asset is the home that you worked so hard to pay for. Well, then that's the other scenario. We want to make sure that we pull that real estate out and do some Medicaid planning. Just so there's clear, you still have that 5-year look back rule, whether it's revocable or irrevocable. So the key is planning. There's a theme here if you can't tell. You want to plan ahead. No one has a crystal ball, of course, regarding their mental capacity, but if you know you don't have retirement income, you don't have long-term care insurance, the only asset you have is your home, you want to be thinking ahead and may want to consider doing some Medicaid planning, so we're protecting that home and able to leave it for your loved ones. Now, I kind of just talked about what is the best strategy when you use a will or trust. What I wanted to show here briefly is, again, why I'm not a big fan of a will, specifically when you have property, because the average, if you're going to probate court, you're going to lose about 10% in liquidation costs. That means attorney's fees, your administrator's fees, or the executor of your estate, accounting fees. Good old Uncle Sam comes in because you don't have some of the tax protections that you do in a trust. So that can be 30%, which means instead of being able to leave 100% of your wealth to your loved ones, they're being reduced to 60% on average. So my goal, again, is to have your loved ones inherit that and not Uncle Sam. And this is why we talk about a trust, because those liquidation costs and those taxes go away or are significantly reduced when you have a trust instead of having a will. So again, 100%, that's my favorite number to go to your loved ones with proper planning. Now, a lot of people think that estate planning is just for the rich, or if I have something. I use this example. John Denver and Frank Sinatra have been gone for many, many years. But the reason I like to show these as an illustration is to show you that trusts have been around for a long time. They've been around for a long time. They're just starting to become more popular, and you hear about them more often because we're in a era, which is a good thing, that more families are having legacies to leave behind. And so you start hearing like, well, how do I best protect it? So using John Denver, when he passed away, he had a $10 million estate. Unfortunately, he died with no will, or you'll hear the term intestate, which means dying without a will. By the time his family ripped each other apart, it was contested over 30 times, they were only left with $3 million. And so you can see just how costly it becomes when you don't have planning ahead, and it ends up, instead of going to your loved ones, I can tell you there were millions of dollars spent in creditors' claims and attorney's fees with his estate. Frank Sinatra, on the other hand, he was gone before I was even alive, had a trust, and his estate was significantly higher than John Denver's. But the key here was, unlike the estate that I think John Denver, they ended up being in court for about 4 years. With Frank Sinatra's estate, they were able to settle it in weeks because, again, with a trust, we bypassed having the need to go through the probate process. So if you do a trust, if you've got some real estate or you've got minor kids and you have a significant amount of money that you want to leave behind for them, but they might be minors, or they may have addiction problems, whatever, or you just may not think they are mature enough to handle a windfall. This is another benefit of a trust, because with a will, it's an outright distribution. You can't make any type of what we call exceptions or delays. So what a spendthrift provision does is, let's say you leave $50,000 or $100,000 behind for your loved one. What a spendthrift does is says, okay, they're to get half at 30, the remainder at 40, whatever age you think is appropriate. The only thing they can use it for is you'll typically hear a term, health, welfare, and maintenance. Meaning, it doesn't mean they can't get access to their funds, but they can't just go out and say to their trustee, I want to buy a Maserati. Well, that's not practical, but maybe a Toyota, Corolla is. So the spendthrift provisions in place so that they don't blow through their inheritance because they've never dealt with such a large amount of money. So a trust also protects your loved ones from themselves, from burning through their inheritance in a rapid manner. The other thing a trust does, it also protects your beneficiaries from predators. You see this a lot with lottery winners, and you hear about them and all their money is gone in a matter of years because it's so overwhelming. They don't get estate planners or financial advisors in their wheelhouse, and their cousins, their brothers, the mothers, everybody's coming out of the woodwork to, I need some help here, I need some help there. And next thing you know, their funds are gone. And so when people, it's like a skunk. They can sniff it a mile away when you have some money. So, a trust also protects individuals from unscrupulous or those who don't have your loved one's interest in heart when they can't get direct access to maybe a large amount of money at one time. So one of the last things I want to make sure I talked about too is my favorite subject, IRAs. An IRA, of course, is an individual retirement account, but it's not just IRAs. It can be a 401k. It can be an annuity. It can be an IRA, a pension. Any retirement account is in danger right now. And why do I say that? A living will or excuse me, a will or a living trust is not going to save your retirement account. What I mean by that is back in 2020, Congress passed what's called the Secure Act, and it was updated in 2022, 2023 to the Secure Act 2.0. And what this means is now, prior to the Secure Act 2.0, you could what we call stretch a retirement account until you were 70 and a half. They've raised the age now to 72, and it'll go to 73 in 2035. Well, on the surface, that sounds great. You're like, oh, I get 3 extra years before I have to start doing these required minimum distributions. There's a catch to that. When you pass and you have retirement account monies that you leave behind, the only ones who can stretch to that age, which again is 72 right now, is surviving spouses. I'm going to repeat that. The only ones who can stretch until they reach that age of 72 is a surviving spouse. If you don't have a spouse, or your spouse predeceased you, and you've left the beneficiaries as your children, well, what the Secure Act 2.0 means is they've got to withdraw all of it within 10 years of your death. This is significant, and because it really went into effect in 2024, you haven't heard a lot about it. But I'm passionate about it because it happened to me when my parents died during COVID. And that's how I kind of stumbled across this. And so I'm a believer in you know better, you do better. And so because my mother passed in 2020 and this rule changed right in 2020, which is why I didn't catch it. But basically what this means is, let's say you have $300,000 in your retirement account and you leave it, and you, in 10 years, if your children are not aware of this rule and they haven't drawn down their money, in year 10, they're going to get a wonderful 1099 with an income of $300,000. And let's say their ordinary income, they make $100,000 on their own. So instead of being taxed at $100,000, you know, their normal salary, in year 10, they're going to get this bill or 1099 that says, now you've added $300,000 of income to your taxable year, which now makes them go to basically earning $400,000 that year. Well, why is that important? In a blink of an eye, they just lost half of their retirement account that they inherited to taxes, because it's put them into a much higher tax bracket. And so it's really important because this rule applies to anyone who has died after 2020, after January 1st, 2020, where now the only way to get around it, there's a few exceptions, but one of the main things that we share with clients, and the general rule of thumb is, if you have a retirement account that's valued at about $400,000 or more, you should look into this trust. It is a specifically designed trust, and it's called an IBT, an IRA beneficiary trust. And this will insulate any retirement account that you have that you left for your loved one, a 401k, an IRA, an annuity, a pension, and thereby, because the trust becomes the beneficiary instead of your children directly, they become beneficiaries of that trust. And it is a workaround so that they can then stretch to 72 just like your spouse could. So again, I wanted to share this because a lot of people, which is great, we always hear about, pay into your retirement account, build your retirement. But using my parents for the example, they didn't get to touch their retirement account because they died before the required minimum distribution was required. And so my sister and I received, a pretty significant windfall. And now I've had to do some tax planning so I don't get hit with a huge tax bill in another, 5 or 6 years when it's all going to have to be drained. So just to recap, this Secure Act 2.0 does not apply to spouses. spouses can still stretch where they're not required to withdraw funds or the requirement and distribution until they reach the age of 72. But if it is anyone that you are leaving your retirement account that is not a spouse, they are going to have to draw it down in 10 years, all of it, unless they look at, and this is one of our areas of specialty of doing a specialized trust, which is again called an IBT or an IRA beneficiary trust, where the beneficiaries get to stretch that just like your spouse would. Now, with that being said, 40% of Americans, like I said before, have zero plan. 40 of the 60% have an inadequate or out-of-date plan, which means 6 out of 10 of us need a plan. I hope what I share with you today, if you don't have your plan, or if you haven't looked at your plan in a while, that you will contact your attorney, call me, doesn't matter. What we want you to do, and what the purpose of this was, is to give you arm you with tools so that you could make informed decisions and get your affairs in order so that you don't fall into any of the pitfalls that we've talked about today. Again, if you're concerned about probate, if you're concerned about your retirement accounts, if you have a blended family, you just want some asset protection, and all this was foreign to you until today, that's why you want to consult with an attorney. So just to recap, what's proper, an estate plan is retirement account planning, protecting your assets from creditors, avoiding estate tax, protecting you while you're living from lawsuits, creditors, divorces, which I should caveat to piggyback on the IBT. When you also create an IBT for your children, if they go through a divorce, it is not touchable. They cannot be forced to split those funds with whoever they're divorcing. So that is all I have. I will open up to questions.
Okay, Valentia, and man, do we have questions.
Right.
That was pretty amazing. And so we do have questions. So I'm going to go in the order as they were received. And of course, because the questions were asked all throughout, you may have touched on a couple of them, but I'll dive right into the first question. My mom has no will or trust, and she has no property. I am the only child. She does have a power of attorney for finances. My name is jointly on her accounts. Does she really need a will or trust?
If the only asset is that bank account, no, because upon her death, the key word in that question was you are on the account with her as a joint account holder. So whoever the survivor is will own that account outright, whoever passes. So if that's really the only asset, unless she has some specific wishes, or if you have siblings, and it's always, you may never have to go to probate, but if there's any concern about making sure her wishes are clear with maybe her personal property, I recommend a will. But in that scenario, the money is fine because it's jointly owned bank account, and based on what you said, the trust wouldn't apply in there, but you may still want to do a simple will just in case it's contested and her wishes are clear.
Okay. Now, this question was giving a synopsis of an irrevocable trust and the reasoning behind it, but you did give that, and I will make the audience aware that this is a recorded session and it is being recorded, and a link can be provided for participants. So we'll go on to the next question. Where do you go to get a will or trust created? Of course, we can come to you, but where else would we go? Does it have to be an attorney?
I always encourage an attorney. I have clients in almost all 50 states because estate planning is contract law. Probate isn't. So if it has to go to probate court, then I'm licensed in the state of Georgia. But if you, a lot of people will try to find something online, and then I'm going to give you a perfect example. Someone came to my office after their loved one passed, and they couldn't figure out why the court said their will was invalid. Because the court can't give legal advice. They'll accept your paperwork, but they're not going to tell you what's wrong with it. And when I read it, it did not have what we call a self attestation, meaning self-proven affidavit, and it did not have a witness. It had a notary, but in Georgia, for a will to be valid, you have to have two witnesses, and you should have a self-proven affidavit. Otherwise, you're going to have to get affidavits from those, if it is a valid will, to get that they acknowledge that you sign, you're of your right mind and sound and body. So when you go online and you download a will and you don't know the rules of your state, you may think you're good because you got it notarized, but it will be considered invalid in Georgia if it does not have two witnesses. You don't need a notary, but you need two witnesses, just as a simple example, to have a valid will here in Georgia.
So one of the questions in the chat is about how much does it cost to get your documents, get a trust or get a will?
Yeah, so it really does depend on how many assets. But in general, to do a simple will, usually you're going to spend about $1,000 to do the will. To do the trust, and when I say trust, it's actually a package. It includes your trust, your portable will, your durable power of attorney, and your balanced health care directive. And generally, if it's a simple estate, maybe it's less than 2 properties, your bank accounts, it averages about $4,500. So that's just to give a range of what a will would cost compared. Now, I share that to say, if you come to my office for probate, this is the retainer, it can go higher. Right now, it's an automatic $5,000 retainer fee. So I'm not going to sit here and say it's not an investment, because it is. But when you think about what you're losing, if you remember, I said it can cost you up to anywhere from 20-40% of your estate if you don't play your cards right when you're dealing with probate. That couple thousand on the front end would have saved you tens of thousands on the back end if you had done a trust. So that's just to kind of give you a comparison of apples to apples.
Okay, that's good. Next question. Can we nominate or identify a minor to be a beneficiary on our bank account?
You can, but I wouldn't, because you can't leave a minor anything directly. And a minor for Georgia purposes, anyone who's under 18. So what would end up happening is a trust would have to be created. Well, why is that significant? Because whoever's creating is what they call a testamentary trust. It may not have been what you wanted, how you wanted your kids to receive their money. Maybe it's too lenient. Maybe it's too, stringent. So when you leave it to a testamentary trust and you leave it to someone else to create that trust for your child, you're taking away your power. So you can leave it to a minor, but I would create a trust for that minor, so that I'm clear my assets are being distributed to my child the way I wanted them. Otherwise, if you pass away and there's still minors when you pass, a testamentary trust would have to be created, and it may not follow exactly what your wishes were.
Okay. All right. Does the person named on the medical directive have to live in Georgia?
They do not. They can be out of the country even. So it's really, I will say this, I'm not a big fan of having out of country, because if I'm in a medical crisis, sometimes time is of the essence. So I do encourage for healthcare directive, at least your primary, because you should always have a backup, just in case that person you've listed, which might be out of the country or out of state, isn't able to be located, then the backup can be contacted. But when it comes to someone's health, not as much about the financial durable power of attorney, but for health, I always encourage clients to at least consider having someone local, in case we need immediate attention and need to get a hold of you rather quickly. But is it required? No. I have clients who have POAs all over.
Okay. If I place my home in a trust, do I have to remove it from the trust before I can sell it?
You do not. You do not.
Good to know. If I have a mortgage on my home and place my home in a trust, what is the bank's posture? Does the mortgage transfer from me to the trust?
No, good question. There's no need to contact your mortgage company, because then they'll talk about what we call the due on sale clause, and they'll scare you thinking that you can't do a trust. What most people don't realize about the security deed, there is a clause in there that says 1 day late, I can foreclose on you. it's no different, right? It's you're late. So if they really wanted to pull that card, they could call the note at any time. So trusts is about title, it's about ownership. Your debt or your mortgage is about who owes me that money. So when you put your house in a trust, the debt still stays in your name because they based it on your social, your credit profile to give you that loan. But the title is, so if I pass away, I can still own the title can be transferred without having to go to probate. And at that juncture, if there's still a mortgage on it, did you have life insurance that you wanted to pay the mortgage off so your kids can inherit it free and clear, or the bank will make them refinance it or to sell it, because most lenders will not let you keep a note in a deceased person's name. So title is two different things than the actual note. Note just says, this is who owes me this money. Title says, this is who owns the property. And so therefore you can certainly, because most of us have mortgages, myself included, and all my properties in the trust, it just allows me to be able to, when I pass away, convey my property to my beneficiaries without having to go through the probate court. But that debt still has to be paid off. So if I haven't left money behind, my family, they can sell it, take the proceeds, pay the mortgage off, or they can refinance it. Where I've set my my personal plan up is my policies will cover. And I share that because maybe you want to leave, life insurance is not as expensive as people think it is, right? And there's different types of life insurance products. But if you want to, leave your house free and clear and you can't pay it down while you're living, life insurance is great about that, because then your loved ones can take those proceeds and pay it off and have the house free and clear.
Okay. If I place my home in a trust, how does that affect my homestead exemption for real estate taxes? Or does it?
Great question. We got some smart people on here tonight.
We have some smart people.
Love it. It does not affect your homestead as long as you are the beneficiary. All this, look at a trust as like a shell. It's like a holding, imaginary holding company. It just means it's being held on my behalf. I am still the owner, which is why you can still sell it when it's in a trust. And so if you're in a county that you're a senior and you get those senior exemptions, those all stay in place as long as you are the primary beneficiary of that trust. So in other words, you're still living in that home, you still get your homestead. If you're of the age and you get the senior discount, all that still stays in place. You do not lose that by putting your house into a trust. That's a great question.
Okay. Is a POD, pay on death, beneficiary established by an attorney in addition to naming a beneficiary with the bank?
No, a POD is, your bank is going to have their own beneficiary designation form. So you contact the bank and say, hey, Valentia, or I'm Valentia, I have two bank accounts and I want to put my nieces as the POD. Then they will hand you whatever their internal beneficiary designation form is, and you file it. You don't need an attorney. You just need to contact your bank and get their internal beneficiary designation form and fill it out and give it back to the bank.
Okay. Can the durable power of attorney be used in real estate matters?
It can, as long as the language is included in your durable power of attorney. So when we draft, there are certain categories. We usually do, there's like 10 or 12. And if you initial by this box that says all preceding, it will cover real estate, it'll cover taxes, it'll cover life insurance. So you can have a restricted or limited power of attorney, or you can have an all-encompassing one. It just, because some people only want you to have a power of attorney to do this one real estate transaction. That would be a limited, and it would expire upon that transaction closing. Or you can have a general durable power of attorney that allows you to handle all real estate matters at any time on my behalf.
Okay. The person is wondering, and they may have missed it, but did you discuss ways to fund the trust other than your property? Also, can you leverage funds from a trust while you are living?
You can leverage anything in a trust because it's your assets. The term funding a trust is not about money. It's about making sure whatever assets that you own are put in the trust. They're retitled from your personal name into your trust name. Otherwise, you will go to probate court because when you die, it's stuck in your personal name. So when you hear the term funding, it's not about putting money in the bank account. It's looking at whatever assets you currently own and making sure you retitle them in the name of the trust.
Okay. Does the 5-year look back rule or 5-year back rule only apply if the loved one is in long-term care?
No, it applies across the board, whether it's a living trust or revocable or irrevocable. Georgia has a 5-year look back rule for all trusts, period. And most states have a 5-year look back rule.
Okay. And do you have to have a trust already in place in order to set up the IBT?
No, you may not own anything. Using that example, maybe you've rented all your life, you didn't want the headache of home ownership. That IBT is only applicable to retirement accounts. So somebody could have a will and have an IBT because they've got $1 million, they've worked at Ford for 45 years and built up this massive retirement account. That is a specially designed trust that only thing it can house is retirement accounts. So one does not necessarily have to do with the other. If you have a retirement account that has a lot of money in it, we're creating that trust to protect, and so your loved ones can stretch until they're 72 as well.
Okay. Do you have a few more minutes for the rest of the questions? I know we're at 8, but okay. All right. Okay. So this is loaded. Are CDs protected or are they even necessary? So I think the second part of that question is if you own a CD and you name a beneficiary, I guess, or is it necessary to name a beneficiary on a CD? I guess that's the kind of the gist of the question.
A CD, because there's certain, so if you remember, I said there's certain things you can't retitle in a trust. And CD is one of them. So what you do is you have the trust be the beneficiary of the CD. So again, if you had minor kids or you just didn't want someone to receive an outright distribution, you make the trust the beneficiary. So a CD cannot be retitled, but you can certainly make the trust, or anyone for that matter, be the beneficiary of the CD. And as far as is a CD beneficial, that's a financial advisor question. I don't know what the person's portfolio looks like. I had a CD. So I moved my money depending on who's giving me the best rate. So, money markets were good for a second and then they went flat and I moved my money over to it because CD you can't touch, right? But the rates were really well. So it just depends on, and I'm no one's financial advisor. We work with financial advisors, but that's really more of a finance question, not a estate planning attorney question.
Okay. So this question, it's what if you have identified beneficiaries on your 401k? I'm guessing that might be related to the IBT. So I know you've answered it a couple times, but the identified beneficiary, if they are not the spouse, then that's where it comes in with they'll have 10 years to.
That's right. So
okay.
if you have a sizable retirement account, because most of it, let's say, I'll use myself for example. I'm not married, right? So my nieces are my retirement funds. They, before this rule applied, because they're adults, I had them, and then I changed it because I don't want them to get hit with a tax liability. So once I had the IBT drafted and I provided that to Fidelity so that they could remove them with their personal names and replace them with their now trusts, so that when I die, which we hope is no time soon, their trust will get the money and they'll be a beneficiary so they can stretch it again until they're 72.
Okay. This question is, I have a house and one child, and how do I start to set up a trust? I would imagine they would get with.
Yeah, it's just a consultation. So, there's a question there that so generally when I'm talking with a potential client, we do a complimentary 30-minute consultation, doesn't cost you anything. And I'm talking to you like we're doing right now. I'm asking you like what your goals are, You know, do you want to hold things in trust? Are they responsible? What, you know, what kind of assets do you own? Just so I can get an idea in order to give you proper suggestions on what direction your estate plan should go. And then if they say, okay, Attorney Eileen, I like what I hear, we ready to start. There's a questionnaire that we have the clients complete, because that questionnaire is the data from that I need to be able to draft your documents. So it starts with an initial consultation where we kind of talk about what your goals are, what you own, you know, basically what your estate plan consists of currently. We give you some advice, determine what makes the most sense for you, and then the next step is to fill out that questionnaire, get it back to us, and that's when we start drafting your documents, whether it's a will or a trust or whatever.
Okay. So this question was how to protect an adult child's Roth IRA from lawsuits or creditors. And I think you spoke to that, but just overall, they would need to contact someone, especially considering a trust would be a good vehicle for that.
Yeah. Now, the good thing
Okay.
is, because with a Roth, I won't get into, gonna make your head hurt. Roth, you paid the dollars, you paid the tax as it was going in. Traditional dollars, which is what most employers have, is tax deferred, right? So you pay taxes when it's coming out, which is why this is such a big deal. If it's a Roth, they won't be able, they're not gonna be paying taxes on it, but they still would have to withdraw it within 10 years if they're, you know, your children, not your spouse. So
Okay.
the IBT would still be beneficial because they're not paying taxes, but if you don't want them to be required to get a windfall of $400,000, you want them to be able to take it as they want as they get older, then that IBT, that special trust, would still be beneficial because it gives them the stretch that they will not have, and would have to, if it's just their names directly, they're going to have to withdraw all that money within 10 years after your death without
Okay.
that IBT.
Okay. I'm going to skip around a little bit. My grandma has dementia and lives in South Carolina. She made my mom the power of attorney, and the land passes down to me if my mom passes. Does my mom need to make a trust on her own, or will my grandma's trust still apply?
Grandmother's trust will apply when your mother inherits the property, because it's not your mom's property yet. It's not your property yet. So upon that person's passing, in order to avoid probate, and you'll see how easy it is. You know, we don't want grandma to leave anytime soon, but you'll see just how simple it is to transfer the property from your grandmother's trust to your mother when she passes. And if mother wants that same type of easy distribution, then mom would want to set up a trust once she inherits that land. If mom owns property already, I still encourage her to get a trust, because now the trust is already created. So when mom inherits the property, she just moves it straight into the trust that already exists. So it just depends on, if mom doesn't own any other real estate, a trust is really not needed right now based on what they've asked. But when she does inherit it, I would strongly encourage, you know, to then get a trust done.
Okay. Can I rent my home from my trust?
Yes, you can.
Okay. If you have a trust that was created 15 years ago, but it needs updating, is the cost about the same as just starting one from scratch?
That's a good question. It depends. If it's minimal, because the investments is in the creation of trust. Typically, what gets amended over time is maybe your beneficiaries change. Maybe you need to add some property, but the core wish of the trust really hasn't changed. So normally, if as long as it's not major changes, our charge is about $700 to because amendments is just a few pages. If it's an overhaul, like it is completely different, it is basically like you might as well just do a whole nother trust, because it's going to cost you about the same. But most people don't change the essence of the trust. They may be changing beneficiaries or adding some properties or something like that, and they didn't realize that it wasn't in the trust already, which is why it's not that expensive if we're just simply doing some basic amendments. That's just going to be a few pages versus you know, a 30-40 page trust.
Okay. I have like 4 or 5 questions, and I know we're going to have a hard stop at 8:15, but for clarity, if a family member passes away, but the title is in my name and they have the mortgage note, will I be forced to sell if I don't qualify for the loan? So I guess if I can't acquire a loan, I'll be forced to sell. Okay.
You most
Okay.
likely will, because I mean, it's a lender by lender decision. So, here's the thing, lenders like, as long as you're paying, fine. Most
Mhm.
lenders are not, because especially if it's, you got to think about who they're underwriting. Like if that house catches fire, that title insurance policy was tied to the decedent's name. So
Gotcha.
it's not a blanket answer. So I don't want to say it's absolute, that you'll be forced. But that's a lender decision, and every lender is different. So most likely, if you can't refinance that remaining balance in your name, then you're most likely going to have to sell. Because what you don't want to do is let it go into foreclosure and then
Right.
the bank take it for pennies on the dollar. But that's going to be a lender specific question.
Right. Okay. What vehicle, or is there a vehicle other than the IBT that people can use to transfer money to beneficiaries from retirement accounts under 400,000? So I think the IBT people are maybe not quite sure. The IBT, it just allows for your loved one who's not your spouse, right, to have a longer period of time
That's right.
to draw down their funds. So that, I think the IBT is something that people may want to dig a little bit more into.
And it can be, that's just a general threshold, because when we charge clients for that IRA beneficiary trust or the IBT, it's about $2,000. So let's say your IRA account only had 50,000. Okay, you got 10 years to draw down 50. If I just took 5,000, 5,000 is not going to bust my income bracket, tax bracket every year. So that's why we say in general, that 350, 400, it makes sense, because when you divide the math in 10, that can move you into a different tax bracket. But there's no threshold for doing an IBT. It's just, I try not to charge people money that they don't have to spend. But maybe it's only 100,000 today, but you work for another 20 years, there's no income threshold. You can open it as whatever you want. I don't want to give that impression. But economically, if it's, less than 100,000 and you divide that over 10 years, that's not going to, and let's say you have two children, so it's like 50,000 a piece, that's not going to be a major tax event for you. So it may not be worth investing and getting an IBT drafted. That's all I'm saying.
Got you. Okay. This might be financial, but what's the purpose of creating an EIN number in the matter of a trust or estate? That
When it's your trust, it should be based, you don't need an EIN number. You base it on your social. We don't get EIN numbers. As long as you're
okay.
the beneficiary, you should use your social.
Okay. And then how do people keep trust going? Because it seems like assets are still distributed as a one-time event, like a will upon death. I know you mentioned in the presentation that you can set up the trust, especially if it's going to a family member or adult child who maybe is not as good with money managing, and it can be distributed over time. So I would imagine that in consultation with your advisor or attorney, you can kind of set up that trust the way you want it distributed. It doesn't have to be a one-time
Correct. I
distribution.
mean, so
Okay.
again, the trust goes away once all the assets have been, for a simple revocable trust. It goes away upon distribution of all, there's nothing to manage anymore. So if let's say you pass and your child is 20 and you've had your trust, they get one half at 25 and the remainder at 30. Then at 30, the trustee has no other further obligations. All the assets have been distributed, and then the trust just dies at that point. So it just depends. You hit the nail on the head. It depends on what you're trying to achieve. If and you may say this trust will remain in effect until they die, because you just don't trust that they're going to be able to be wise at any given moment. That happens sometimes. Or like I said earlier, I see this a lot with families who love their children, but they know they have substance abuse issues. And if they give them a windfall, they're going to blow it. So rather than them spending it on drugs or, whatever the case may be, they hold it in trust for their whole life. And they have to go to the trustee to get distribution. So it can go on and literally until your loved one passes away too, that you're leaving this behind for.
Okay. I have one that is both parents are deceased. Their names are on the only names on the deed. They have 11 children. What would be the best procedure to put the name in the children's name, or do we have to go to probate court? I guess if it was whether or not it was a will.
Oh, it doesn't matter if there was a will.
Mm,
If based on that question,
mhm,
hopefully they're still on, they can just take a picture of the screen and call me. If the
mhm,
house was in mom and dad's name only,
mhm.
whether you have a will or not, you're gonna have to go to probate court because it's stuck in now in two deceased people's names. And therefore, if you go to try to sell it, divide it, whatever, no one has the legal authority. No one is the representative of the estate. And unfortunately, depending on how the deed was drafted, if it doesn't have rights of survivorship, they may have to probate both mom and dad's estates. I won't get into what rights of survivorship means, but based on the way the question was written, unfortunately, you're going to have to go to probate because no one has the power to do anything with the property right now.
Okay. We're going to close there. You have dropped some knowledge on us tonight. I
Okay,
would hope
let's
that
go.
the audience would, we have had your information on the screen, but of course, if, and we would love for people to reach out to you, but if not, reach out to someone because this is so important. We are certainly appreciative of you for presenting tonight. And we do ask our audience participants, please take a moment to scan the QR or type in the job because we want to continue to bring great webinars to you, and we want your feedback. We thank you for the hearts and the claps. Thank you. But the survey input is even better because that's how our presenter can get specific feedback, and that's how our committee can provide additional programming that meets your needs. So with that, we will just leave this survey link up just for one more minute. Please fill out the survey. The form is also in the chat. And we absolutely wish you all a great evening. Thank you so much for your time and attention.
On behalf of the Atlanta Suburban Alumni Chapter of Delta Sigma Theta Sorority Incorporated and the Economic Development Committee, we thank you for attending tonight's webinar. We hope you found the information valuable and learned some actionable steps you can take now. We have provided a tiny URL and would appreciate your feedback by completing the short survey. Your input allows us to continue to develop informative and poignant programming. Thank you and have a great evening.